This is a community-supported legal education channel. Find out how you can support our mission at the links in the description below.
All right, let's take a look at this new complaint, fairly new. I guess it's a couple months old. It's from September 10th, but we have recent things happening, that's why. This is Nintendo of America versus Matthew Storman and John Doe's 1 to 10. This is the ROMUniverse case. Last year, Nintendo went after a different ROM site. Now they are suing ROMUniverse for similar kinds of things. Let's see what their complaint is. We're not going to go over it in every detail because what I want to get to is the motion to dismiss from ROMUniverse and Nintendo's response. And then we're going to talk about Larry Rudolph from Redigi. Defendant Matthew Storman and persons of unknown identity own and operate the website ROMUniverse, built largely on brazen and mass-scale infringement of Nintendo's intellectual property rights. The website is among the most visited and notorious online hubs for pirated Nintendo video games. Through the website, defendants reproduce, distribute, monetize, and offer for download thousands of unauthorized copies of Nintendo's video games. This includes games for nearly every video game system Nintendo has ever produced, including hundreds of games for its recently released Nintendo Switch, so even recently released games. Not that that's much of a defense. According to the website, as of the date of filing this complaint, hundreds of thousands of copies of Nintendo games have been illegally downloaded through the website, including nearly 300,000 downloads of copies of pirated Nintendo Switch games and more than 500,000 copies of pirated Nintendo DS games. Nintendo of America is from Washington. Matthew Storman is a natural person in Central District of California. Let's see. We know what Nintendo is. We know what they do. And now they're going to talk about piracy. You can somehow get the ROMs off of the cartridges. I'm assuming there's either a dump feature or you actually can read the whole thing somehow. I don't know how they do it. I'm even like an amateur embedded engineer, but I don't actually know how you would break through Nintendo's copy protection on there. And I know chips generally have a command or a pin that you can dump the contents of the chip, so I'm assuming they figured out a way to bypass the things and dump the contents of the chip. On or about 2009, defendant Storman sent an email to members of the website noting that he would be adding new content, including ROMs for various Nintendo game systems. In this email, defendant Storman advertised that website users could purchase premium memberships for $30 per year to get access to unlimited downloads and download speeds with no advertisements. In 2018, around the time that Nintendo successfully enforced its intellectual property rights against other infringing ROM websites, defendant Storman bragged that his website would continue to offer ROMs. After the removal of other infringing ROM websites, internet traffic to his website increased. And so it has attracted lots of attention. 400,000 visitors a month, 20% in the United States. And it looks like this: 60,000 ROMs, movies, ebooks, 375,000 members. I don't know if that means premium members paying $30 a year. Here they show a screenshot of 1.46 terabytes of DS ROMs, totaling over 400,000 somethings, I'm guessing downloads, and 3,000 titles. Here's Mario Kart 8 Deluxe with 15,000 downloads and a bunch of other stuff. Super Mario Odyssey, New Super Mario Bros. U. It shows details. You can get Super Mario Odyssey in English, French, German, Spanish, Italian, Dutch, Russian, and Japanese. For several of the pirated games, they even offer box art. Hey, look at that. You can go print box art. Full-service piracy website. The pirated games can be played on computers, phones, or other devices with an emulator. When pirated games are played, they display counterfeit copies of Nintendo's trademarks. Similarly, counterfeit copies of marks appear during the gameplay of pirated games. So in other words, these are not from the proper sales channels, so they shouldn't have Nintendo's mark on it. I'm sure that Nintendo would also be saying, well, you removed our mark if they removed the mark. It is still some kind of trademark infringement. And then since 2013, they've offered $30 one-year memberships. Members can download unlimited number of copies, etc. So copyright infringement, trademark infringement, California unfair competition.
So I just have a question about how this works. For that website, they said that they would be adding things. So this doesn't sound like, for example, a torrent site where they're saying, oh, we're just like a cataloging service. We don't actually host any of the files. We don't know what people put up. So therefore, like, you can't come after us. This sounds like the website is curating these files.
Well, I'll let Matthew Storman answer your question. He has filed a memorandum in support of his motion to dismiss, in which he says he is a service provider of the websites NDS Universe and ROMUniverse.com, and he's been sued for copyright infringement, trademark infringement, and unfair competition. Plaintiffs' claims are solely based on digital material on these websites. Section 512 of the copyright title provides service provider, which is how he's referring to himself, with liability protection and limits relief for the plaintiff to only injunctive relief, or basically an order to remove the things from the website. The plaintiff has previously recognized defendant's right to infringement liability protections under the DMCA. He doesn't cite that yet, so let's take that with a grain of salt. Furthermore, the copies and trademarks on the websites were previously sold by plaintiff, and under the first sale doctrine, the plaintiff has no rights to these copies or trademarks. Yeah, that's not right. That's not how that works. Competition cannot be unfair since the copies have been sold by plaintiff to owners, and under the first sale doctrine, the owners may dispose of the copies as they see fit. The defendant is not selling the copies or trademarks. Defendant prays the court dismiss the suit based on legal, procedural, and common law considerations or on its own. He even uses sua sponte. Is he represented by? No, he is pro se. So then he says, plaintiff has been in communication with service provider at the address admin@romuniverse.com for years. The Digital Millennium Copyright Act protects service providers from liability when potentially infringing material is on its website. Okay, that's not really a great summary of that, but okay. DMCA is also known as ASILA, Safe Harbor, etc. Essential to protection are providing copyright owners inspection access to website, requires owners to properly request the removal of material if owner has a good faith belief it is infringing. The request for removal must be proper and the material is removed. Plaintiff has recognized defendant's rights under the DMCA by sending requests to remove potentially infringing material from the website. These requests were honored by defendant. I don't know, do you believe that statement? That because plaintiff sends DMCA requests, that somehow reinforces ROMUniverse's claim that they're just the service provider? I don't know about that one, but let's continue. Copies on a website of potentially infringing materials may be owned by persons who legally acquired a copy, multiple copies, or collections of the copyrighted material. This is known as the first sale doctrine, he says. The copies do not belong to the plaintiff. These first sale doctrine copies may be sold, destroyed, lost, or given away for free by the owner. The number of copies not owned by the plaintiff is equal at least to the number of copies sold or given away by the plaintiff, his distributors, or suppliers. The first sale or exhaustion doctrines also apply to trademarks. There are other copies that may not be infringing, including fair use, expired uses for education, research, storage, loss, damage, exemptions from anti-circumvention, and those beyond a statute of limitations. The plaintiff has not properly requested any of the copies referred to in the complaints be properly removed as is required under the DMCA, especially regarding specificity, timeliness, and penalty of perjury. What? I'm not sure what he means by that. So the penalty of perjury part, when you send a DMCA takedown notice, there is a format for it that you must include a link to the allegedly infringing material. It must be, I don't know what he means about timeliness. There's no timeliness for a DMCA. Like if there's something infringing on a website, I can send a DMCA anytime. And if they didn't include the statement that says under penalty of perjury that they make the following statements, I don't see, I mean, it is material to it. It is a requirement of the law. So if he's saying he disregarded notices because they didn't contain a statement that the claimant makes the claim under penalty of perjury, I don't know if that actually totally invalidates a DMCA. I would think it's still some kind of notice, even if it doesn't make it a DMCA notice. But before we go further there, I thought maybe we should learn a little bit about the first sale doctrine and how it applies to digital copies. A few years ago, I had the pleasure to meet Larry Rudolph from a company called Redigi, who is trying, or was trying, to make the world's first digital market for the resale of digital copyrighted goods. You buy a song, you buy a game, whatever. If it is digital, he wanted to be the guy, the company that made all the agreements and made all the technology to make it work so that you could sell your digital copy. So an iTunes song or a Steam game. These are examples. I'm not speaking for Larry. I'm not speaking for Redigi. This is just my understanding, is that this is the sort of thing that would be negotiated if you later wanted to sell your Steam game or you wanted to sell your iTunes music or something. You would be able to upload it to a website. They would process it, evaluate it, everything, somehow disable your copy, and then enable it to be sold to somebody else. So I'm not sure how that was ever supposed to work, but Capitol Records sued Larry Rudolph and Redigi. It was Capitol Records, Virgin Records against Redigi, Joel Ossenmacher, Larry Rudolph, etc. And the judge says, defendant Redigi and its founders, Larry Rudolph and John Ossenmacher, appeal from the judgment of the United States District Court for the Southern District of New York in favor of Capitol Records and Virgin Holdings. Great name. Finding copyright infringement. Defendants had created an internet platform designed to enable the lawful resale under the first sale doctrine of lawfully purchased digital music files and had hosted resales of such files on the platform. The district court concluded that, notwithstanding the first sale doctrine, Redigi's internet system infringed the plaintiff's copyrights by enabling the resale of such digital files containing sound recordings of plaintiff's copyrighted music. We agree with the district court that Redigi infringed the plaintiff's exclusive rights under the law to reproduce their copyrighted works. We make no decision whether Redigi also infringed plaintiff's exclusive rights under section 106.3, which is either derivative or display or distribution. Background. Plaintiffs are record companies which own copyrights or licenses in sound recordings of musical performances. Plaintiffs distribute those sound recordings in numerous forms, of which the most familiar 20 years ago was the compact disc. Today, plaintiffs also distribute their music in the form of digital files which are sold to the public by authorized agent services such as iTunes under license from plaintiffs. Purchases from Apple iTunes online store download the files onto their personal computers or devices. Redigi was founded by Ossenmacher and Rudolph in 2009 with the goal of creating enabling technology and providing a marketplace for the lawful resale of lawfully purchased digital music files. He wasn't trying to commit copyright infringement. I think he was really trying to be the trailblazer for digital music sales after the first sale. Ossenmacher served as their CEO and Rudolph as their chief technical officer. During the period addressed by the operative complaint, Redigi hosted resales of digital music files containing the plaintiff's music by persons who had lawfully purchased the files from iTunes. Redigi was not making efforts in the shadows to infringe on copyrights. To the contrary, it invented a system designed in good faith to achieve a goal generally favored by the law of copyright, reasonably hoping the system would secure court approval as conforming to the demands of the Copyright Act. So he was wrong, but the court even says here that this was a sincere attempt to make a system that complied with the spirit of the law, hoping for court approval. He did not get it, at least not so far. The district court entered a stipulated final judgment of $3,500,000 and permanently enjoined defendants from operating the Redigi system. In the stipulated settlement, which is an agreement to end the case, defendants reserve the right to appeal solely from the district court's finding of liability for reproduction and distribution. Defendants timely filed this appeal. The appeal was stayed as a result of defendants' bankruptcy proceedings. The stay was lifted December 12, 2016. The primary issue on appeal is whether the system lawfully enables the resale of users' digital files. Under the first sale doctrine codified in Section 109A, the rights holders' control over the distribution of any particular copy or phonorecord that was lawfully made effectively terminates when that copy or phonorecord is distributed to its first recipient. Let me go over that carefully. The owners, the rights holders, that's Nintendo in the Nintendo versus ROMUniverse case. Nintendo has control over the distribution of any particular copy until that copy is purchased and distributed to its first recipient. Under this system, it is well established that a lawful purchaser of a copy of a book is free to resell, lend, give, or otherwise transfer that copy without violating the copyright holder's exclusive right of distribution. So I buy a book and I can read the book, get utility out of the book. I can exhaust my utility in that book. The book has no more value to me as a first-time read-through of the book. Maybe it has sentimental value. Maybe it has collector value. Maybe it just has value to me. But its value in utility is reduced because now I have read it and I know what's in it. Maybe I'm not going to read the book again. So to me, in this hypothetical, the book is worthless. But I can take that book and I can sell it to you at whatever value we work out. Maybe it's $10, maybe it's $40. I know some books go out of print and you can't get them anymore, and they sometimes go up into the hundreds of dollars or thousands of dollars for one copy of a book. The copyright holder has no right to control your redistribution of that copy of the book. Very important. The copy so resold or retransferred may be retransferred again and again and again without violating the exclusive distribution right of the original copyright holder. This is the Kurtzsang v. John Wiley & Sons case. That's the Dummies books. John Wiley & Sons is the Dummies books. This is Quality King Distribution v. Lanza Research International. I don't remember who that is. This is Bob's Merrill v. Strauss, another very important case. I forget what that one was about too. These are the progenitors of, or rather, these are the progeny of the first sale doctrine. These are the precedents that spell out the first sale doctrine. Quote, placing a lawful copy of a work in commerce exhausts the distribution and display rights with respect to that particular copy. It is undisputed that one who owns a digital file from iTunes of music that is fixed in a material object qualifies as the owner of a particular phonorecord lawfully made. Thus, they are entitled under 109A to sell or otherwise dispose of the possession of that phonorecord without violating the distribution right. On the other hand, Section 109A says nothing about the rights holder's control over reproduction of a copy or phonorecord. Do you see the distinction? If you can distribute your physical copy in the way that physical copies get distributed, if I give my book to Kaylee, that's redistributing under 109A. If I copy my book and give it to Kaylee and then destroy my copy, not the same thing. The district court found that resales through Redigi were infringing for two reasons. The first reason was that in the course of Redigi's transfer, the phonorecord has been reproduced in a manner that violates the plaintiff's exclusive control of reproduction under 1061. The second was that the digital files sold through Redigi, being unlawful reproductions, are not subject to 109A's first sale doctrine, which applies solely to a particular copy or phonorecord lawfully made. We agree with the first reason underlying the district court's finding of infringement. As that is a sufficient reason for affirmance of the judgment, we make no ruling on the district court's second reason. Redigi argues on appeal that its system effectuates a transfer of a particular copy, that the user lawfully purchased from iTunes, that it should not be deemed to have reproduced that file, and that it should therefore come within the protection of 109A. Redigi makes two primary contentions for this. First, Redigi asserts, as it must for its argument to succeed, that the digital files should be considered material objects, and therefore, under Section 101's definition of phonorecords, a material object should qualify as eligible for protection under first sale. Second, they argue that from a technical standpoint, its process should not be seen as making a reproduction. Redigi emphasizes that its system simultaneously causes packets to be removed from the file remaining in the consumer's computer as those packets are copied into the computer buffer and then transferred to the Redigi server, so that the complete file never exists in more than one place at the same time, and the file on the user's machine continuously shrinks in size while the file on the server grows in size. I mean, give him some credit. He was really trying to do this. I mean, this is how you would do it. I'm not getting down on Larry. I think he was a genius. It's just not what the law says. Redigi points out that the sum of the size of the media stored in the original purchaser computer and Redigi's server never exceeds the size of the original file, which, according to Redigi, confirms that no reproductions are made during the transfer process. As for the first argument, that the digital file it transfers is a phonorecord, we do not decide this issue because we find that Redigi effectuates an unlawful reproduction even if the digital file itself qualifies as a phonorecord. As for the second argument, we reject it for the following reasons. The Copyright Act defines phonorecords as material objects in which sounds are fixed by any method now known or later developed, and from which the sounds can be perceived, reproduced, or otherwise communicated, either directly or with the aid of a machine or device. Accordingly, when the purchaser of a digital music file from iTunes possesses that file, embodied for a period of more than transitory duration in a computer or other physical storage device, that device, or at least the portion of it in which the digital file is fixed, the hard drive, becomes a phonorecord. In the course of transferring a digital music file from the original purchaser's computer through Redigi to a new purchaser, the digital file is first received and stored on Redigi's server, then, at the new purchaser's option, may also be subsequently received and stored on the new purchaser's device. At each of these steps, the digital file is fixed in a new material object for a period of more than transitory duration. I believe the Cartoon Network case involved RAM. The fixing of a digital file in Redigi's server, as well as the new purchaser's device, creates a new phonorecord. So they're saying that even if they agree that the digital file qualifies as a phonorecord, the definition for a music record basically, that even if it does, they still are making unlawful copies because they're putting it on a new device. Therefore, it is a new phonorecord if that device is a phonorecord. Redigi's process for enabling the resale of digital files thus inevitably involves the creation of new phonorecords by reproduction, even if the standalone digital file is deemed to be a phonorecord. As for the argument that Redigi copies a packet of data, then deletes the equivalent packet in the user's device so that the amount of data in the transfer process remains constant, this does not rebut or nullify the fact that an eventual receipt and storage of that file is on Redigi's server as well as in the new purchaser's device, and does involve the making of new phonorecords. Unless the creation of those new phonorecords is justified by the doctrine of fair use, which we discuss and reject in a later portion of this opinion, the creation of such new phonorecords involves unauthorized reproduction, which is not protected or even addressed by 109A, the first sale doctrine. So let me just skim this for a little bit here. He's saying that it resides in the buffer for less than a second, and the court says no, it still remains for more than transitory duration. There's a good argument to be made there, but the court disagreed, and this did not get returned by the Supreme Court for further proceedings. This, I believe, did not even go to the Supreme Court and was not appealed further. We'll check it, I guess. We conclude that the operation of Redigi version 1.0 and effectuating a resale results in the making of at least one unauthorized reproduction. Unauthorized reproductions is not protected by 109A. It violates the rights holders' exclusive reproduction rights under 106.1 unless excused as fair use, and they conclude that it is not fair use. And we're not going to go into fair use because it's another 7 pages or so. And I don't know that it really applies to the ROMUniverse case. We conclude by addressing policy-based arguments raised by Redigi and its friends of court. They contend that Redigi's version 1 ought to be validated as in compliance because it allows for realization of an economically beneficial practice originally authorized by the courts in the common law development of copyright, the first sale doctrine, and later endorsed by Congress when Congress codified or made the first sale doctrine into law in Section 109A. They also contend that the Copyright Act must be read to vindicate purchasers' ability to alienate digital copyrighted works, meaning sell them, under the first sale doctrine, emphasizing that 109A is styled as an entitlement or right rather than a defense to copyright infringement, without regard to a technological medium. On this score, they rely heavily on the breadth of common law first sale doctrine and on a purported imperative described as the principle of technological neutrality by Amici and the equal treatment principle by Redigi, not to disadvantage purchasers of digital copyrighted works. That sounds very close to the European Union equal treatment principle, which we don't have in the States. Not to disadvantage purchasers of digital copyrighted works as compared with purchasers of physical copyrighted works. As for whether the economic consequences of Redigi's program are beneficial and further the objectives of copyright, we take no position. Courts are poorly equipped to assess the inevitably multifarious economic consequences that would result from such changes of law. So far as we can see, the establishment of Redigi's resale marketplace would benefit some, especially purchasers of digital music, at the expense of others, especially rights holders who, in the sale of their merchandise, would have to compete with resellers of the same merchandise in digital form, which, although second-hand, would, unlike second-hand books and records, be good as new. Furthermore, as to the argument that we should read the first sale doctrine to accommodate digital resales because the doctrine protects a fundamental entitlement or right without regard to the terms of 109A, we think such a ruling would exceed the proper exercise of a court's authority. The copyright statute is a patchwork, sometimes varying from clause to clause, as between provisions for which Congress has taken control, dictated both policy and the details of its execution, and provisions in which Congress approximatively and provisions in which Congress approximately summarized common law developments, implicitly leaving further such development to the courts. The paradigm of the latter category is Section 107 on fair use. See Campbell v. A. Cuff-Rose Music. Congress meant 107 to restate the present judicial doctrine of fair use, not to change, narrow, or enlarge it in any way, and intended that courts continue the common law tradition of fair use adjudication. In passing the statute, Congress has no intention of normatively dictating fair use policy. In the provisions here relevant, Congress dictated the terms of the statutory entitlements. Notwithstanding the purported breadth of the first sale doctrine, as originally articulated by the courts, the copyright statutes, while protecting the owner of the copyright in his right to multiply and sell his production, do not create the right to impose a limitation at which the book shall be sold at retail by future purchasers. Congress, in promulgating 109A, adopted a narrower conception which negates a claim of unauthorized distribution in violation of the author's exclusive right, but not a claim of unauthorized reproduction in violation of the exclusive rights provided by 106.1. If Redigi and its champions have persuasive arguments in support of the change of law they advocate, it is Congress they should persuade. We reject the invitation to substitute our judgment for that of Congress. And with that, so did Larry Rudolph's and Redigi's and anybody's hopes of getting a first sale doctrine recognized for digital files. So far, there is no first sale doctrine in digital files, and you cannot transfer from a physical medium to a digital medium and then redistribute that file and claim first sale doctrine as a defense. It does not work that way. So when ROMUniverse comes along and says that they have a first sale doctrine right to do the ROM copying and things, that's not it. That's not going to be a valid defense. So he continues, plaintiff's complaint obfuscates and makes no mention of the DMCA, offers no claim or proof of ownership of the copies on the websites. What? Offers no complete or full description of copyright registrations belonging to complainant. Okay. Plaintiff offers no accurate or complete description of copy contents for defense. I don't know what that means either. Plaintiff may have violated copyright law by not fully and completely describing. No. Copyright law is inadequate as a means of protecting digital matter. No. Plaintiff fails to disclose where the original copyrights are registered. I mean, we could go back and look. They do have to show registration of their copyrights, but as long as they're registered. So he bases his motion to dismiss on a lack of subject matter jurisdiction, saying the court does not have jurisdiction over this matter because of liability immunity and proof ownership of copies has not been claimed. Plaintiff is a Japanese or German company. Okay, lack of subject matter jurisdiction would mean the court doesn't have subject matter jurisdiction over copyright or trademark or unfair competition. Lack of personal jurisdiction. Defendant is not an individual, but rather a service provider. I don't think so. I think they've sued Matthew Storman. I believe it says Matthew Storman. Let me go take a look here real quick. So yeah, it says Matthew Storman. I mean, maybe they could amend it later to include a business. The court does not have personal jurisdiction because SP is protected under DMCA. That's not it. No. Lack of personal jurisdiction means they sued you in the wrong place. Means they sued you in the wrong district. That's what that means. Improper venue means they sued you in the wrong court, in the right district, usually. Insufficient process means they didn't get the summons, or the summons is deficient. Insufficient service of process means they didn't serve you properly. This is the only one that you really should be filing a motion to dismiss like this for. Failure to state a claim. Here's where you would say that they didn't show any copyright, that their basic case that they make out fails as a matter of law, not as a matter of fact. 7, failure to join a party under Rule 19. The plaintiff has failed to join the true and essential owners of the copies known only to plaintiff. No, I think they're suing you for the copyright infringement, not the uploaders. Exhaustion of non-judicial remedies. DMCA provides the plaintiff with an administrative process to have service provider potentially remove infringing copies. Plaintiff is, in effect, asking the court to do what the plaintiff can do non-judicially, and so they have some kind of duty to exhaust their administrative or non-judicial remedies. Yet that's not copyright. Copyright does not have a requirement for you to exhaust administrative or non-judicial remedies. Where you might see this is with the EEOC, the Equal Employment Opportunity Commission, for your job. Before you can sue your company for an EEOC violation, you have to go through the EEOC. And that's not legal advice, that's just what I know from having actually done it. If that could have changed, and that could be different in your state. So please, I am no employment lawyer. Talk to a good and experienced employment lawyer, not Donald Russo. He's been suspended for 3 or 5 years or something for not doing his job. That was my attorney.
I mean, you would probably have a lot fewer clients if you had to exhaust the DMCA remedies before you could go to court. because you represent people who get sued for downloading BitTorrent.
Yes, I would have no clients if they had to send DMCA notices first. And we have definitely explored that in research, and you do not have to send DMCA notices before you sue. I wish you did. And then something about the arrangement in these previous communications. Troubling is the fact that plaintiff has previously and successfully requested the service provider remove website copies, and he complied. The arrangement in these previous communications are an implied contract that any copies challenged by plaintiff will not result in further legal action. Quote, therefore, I request that you take immediate action to remove or disable access to unauthorized copies of the Nintendo game listed at the URLs below in order to prevent further legal actions from your company, against your company. This implies copies not challenged are permitted. No.
No. Imagine if that was an actual defense. It'd be like,
no.
Officer, you pulled me over for the broken taillight and then gave me a ticket for that. So now you can't charge me with drug possession because you only pulled me over. Like anything else I was doing was implicitly legal.
So I, as a defense attorney, I could certainly use this sentence if they sued him over something that had been taken down and remained taken down, and he complied with the DMCA notice. That does not prevent them from suing over things that are currently on the website or suing you to get to the discovery part of the action where they can then ask you questions under oath about what you knew at what time and find out from there. This also implies copies not challenged by plaintiff are permitted on the website until challenged. No, that's not how the law works. The plaintiff receives unpaid advertising on the websites in return. That doesn't matter. Like, you could send them a bucket load of money. That still doesn't mean you have authorization to infringe on their copyrights. And then due process, basic fairness. It is unfair for plaintiff to not adhere to the DMCA protections for defendants. Yeah, that's not due process. Due process is notice and an opportunity to respond in court. He's literally responding in court, and then Nintendo responds to him, so he's definitely got his due process. It says that DMCA is an integral part of copyright law and covers digital material on websites and must be adhered to in any copyright complaint, and the plaintiff has not. And then he makes the first sale doctrine argument again. How do we feel about the first sale doctrine argument now that we've gone over the Redigi case? I don't think there's any first sale doctrine defense, and all I did was read one case. Since DMCA protects service provider from any liability, no. The DMCA protects service providers from liability for copyright infringement of their users if they comply with the DMCA. And so now he's accusing them of abusive process. Unfortunately, abusive process is a claim, and you have to assert that as a counterclaim, and I don't see any counterclaims in here, but we'll take a look. Plaintiffs' complaints are themselves a violation of the DMCA in that the complaints are based on liability-protected material in the websites. Further, they have not offered any proof that the copies on the websites are the property of the plaintiff. They say that there needs to be serial numbers, dates, origins, and who owns a copy. I'm not sure where they get that from. I don't see any basis for that in law or fact. The plaintiff sells, donates, gives away copies of the copyrighted material to copy owners. Well, I mean, the plaintiff has the right to do whatever the heck it wants with its copies. A non-plaintiff copy owner has the right to sell, destroy, or give away physical copies. We saw that, right? The owner may own several copies. A copy is permissible for education, research, reverse engineering, or other purposes. Yes, for personal purposes, not for redistribution to everybody else. Plaintiff has not properly requested, as in a DMCA takedown notice, I think. So they say that the complaints are premature. That's not true. Cease and desist. They say that the plaintiff did not send cease and desist notices. Yeah, they don't have to. I don't know. Where do people get this idea that, like, you're required to send a cease and desist notice? Just because they see lawyers send one, they think it's required? I don't know. The sending of a cease and desist notice is great if you have a cooperating party who you think is going to work with you. Does this sound like it would have benefited from a cease and desist notice? And for all we know, they sent dozens of them and they were ignored. It's not like Matthew Storman's response is going to say all that. Plaintiff previous contacts were from Germany, and since copies do not belong to plaintiff, there are issues of ownership, insufficient process, etc. Okay, let's see. He has his own references section, which kind of reminds me of the law section from Edward Thomas Kennedy. The term service provider is an OSP or ISP. Yeah, that's normal. Digital Millennium Copyright Act. Yes, the online copyright infringement. Okay, that is how it's spelled. Okay, Asilla. Creates a safe harbor for online service providers against copyright infringement. Yes. OSPs must adhere to and qualify to the law to remain in their safe harbor when they receive notice of an infringement claim. So where does that say that they have to do it? It doesn't. It doesn't say anywhere in here that they have to use this process. It says when they use this process, the service provider has to comply. And of course, they have to have registered copyrights. If you think Nintendo doesn't register their copyrights, you're probably wrong. And then they go into trademark, which we're going to skip here. And then he goes into what the elements are of a DMCA notice. And that's more or less correct. I don't know if that's a copy of the law or not, or his rewording of it. And he gives an example here. Dear sir or madam, we have detected unauthorized copies of Super Mario Odyssey hosted on your services. Here's the URLs. The copyright and other intellectual property rights are owned by Nintendo. I declare under penalty of perjury that I am authorized to act. I therefore have a good faith belief. I request you take them down. Here's the link. Yeah, that's a valid DMCA takedown notice. What's the problem with that? So if he thinks that's not a valid DMCA takedown notice, that is incorrect. That is a valid DMCA takedown notice. And I would caution a client showing me such a takedown notice to comply with it, not to ignore it. And then he cites Worth v. Selden, a 1975 Supreme Court case in which the court reviewed judicial standing and affirmed that plaintiffs who lack standing cannot maintain a case. Yes, that's true. What is standing? It means that the injured party has to be actually injured or have an imminent injury. It has to be a concrete injury, not just like some theory of injury. They have to be in this case, copyright owner or somehow an injured party who had a license or something. Nintendo has standing. This is a waste of the court's time, basically. Let's see what Nintendo thinks about this. Now, they have scheduled a hearing, January 14th, 2020, 10 a.m., courtroom 8B of the Central District of California before the Honorable Consuelo B. Marshall. And so Judge Marshall will hear that. If anybody would like to attend that hearing, we'd love to hear more about what happens there. So they have 10 pages, just 10 pages to refute that. And a bunch of it is citations and authorities. And more authorities. So they only have 7 pages to go. Let's check it out. Defendant Matthew Storman owns ROMUniverse built on brazen and mass-scale infringement of Nintendo's intellectual property rights. Through its website, Mr. Storman reproduces, distributes, monetizes, and offers for download thousands of unauthorized copies of Nintendo video games. Thus, Nintendo brought this action to stop his rampant infringement. Nintendo more than adequately pled all these claims. Mr. Storman's arguments to the contrary, even generously interpreting his motion, as Nintendo does in this opposition, completely missed the mark. Indeed, to the extent these arguments can be understood, the motion primarily advances 3 affirmative defenses that are not properly the subject of a motion to dismiss. Correct. Where do you make your affirmative defenses? Federal Civil Procedure 8 says you make them in your answer, not in a motion to dismiss. Now, a motion to dismiss does usually come before an answer, or else you lose some of your motion to dismiss rights. FYI. The motion primarily advances those 3 affirmative defenses. His smattering of passing references to other legal arguments are similarly unavailing. For these reasons, the court should deny the motion. Nintendo goes into itself again. Nintendo's popularity has made it a frequent target. There are ROMs. Mr. Storman, who operates a website where you can upload and provide unauthorized copies to the general public. Mr. Storman's website offers thousands of illegal copies of Nintendo video games for download. In 2009, Mr. Storman emailed members of his website that he would be adding new content for various game systems. In 2018, Nintendo took down other ROM websites, and Mr. Storman bragged that he would continue to offer copies for Nintendo games. Under his control and management, the website has attracted hundreds of thousands of viewers each month, leading to hundreds of thousands of downloads of unauthorized copies of Nintendo's video games. In addition to the infringing software code, the website contains images of box art, which is also unauthorized, and they display counterfeit copies of Nintendo's trademarks because they're not properly licensed. Mr. Storman directly profits. While non-members are limited to one free download through the website, premium members pay $30 per year and can download unlimited files and games at higher speeds than non-members. A motion to dismiss under Rule 12b6 tests the sufficiency of the complaint to state a claim for relief that may be based either on a lack of cognizable legal theory or the absence of sufficient facts pled. So, law and fact. To survive a motion to dismiss, the factual allegations need only be sufficient to state a claim to relief that is plausible on its face. All material factual allegations in the complaint are assumed to be true, so for the purpose of a motion to dismiss, they assume that the allegations are true, and any reasonable inferences that need to be drawn from them must be construed in a light most favorable to the plaintiff. This is the motion to dismiss standard. This is just the first hurdle. In ruling on a motion to dismiss, the court may consider only allegations contained in the pleadings, exhibits attached to the complaint, and matters properly subject to judicial notice. Now, I'm not sure if you noticed something here, but I want to show you something clever that Nintendo did. Let's go back up to the top here. What page were we on? Just going by really, really quickly. So who is our judge? The Honorable Consuelo B. Marshall. And then we come back down here to page 6, where we just were, right? Look what they've cited to. Safina v. Voltage Pictures, decided by Judge Marshall. Delgado versus a welfare plan by Judge Marshall. That's how you do it when you do it, by the way. Finally, although courts in the Ninth Circuit are generally more lenient with pro se litigants, courts have no obligation to build substantive arguments for said pro se litigants. At best, the motion can be understood. Mr. Storman argues that Nintendo has not stated a claim for copyright infringement, raises 2 copyright and 1 trademark defenses, or affirmative defenses. By the way, affirmative defenses means the allegations are true, but I have a legal defense. I have like a basis in law for a legal defense. These arguments fail. First, Nintendo has pled the facts necessary to allege prima facie or basic copyright infringement claims, and Nintendo can provide much more. Nintendo properly pleads ownership of valid copyrights and facts supporting Mr. Storman's infringement of those copyrights. Second, Mr. Storman's assertion of various affirmative defenses, first sale and safe harbor, in a motion to dismiss is procedurally improper and substantively wrong. Finally, to the extent Mr. Storman makes such arguments, his jurisdictional and related musings are without merit because he does not deny any of Nintendo's material, subject matter jurisdiction, personal jurisdiction, or venue allegations. So plaintiffs must plead ownership of a valid copyright and that defendant violated at least one of the 106 rights. A plaintiff properly alleges ownership in the copyrights by providing the title and United States Copyright Office registration numbers. The exclusive rights granted to copyright holders include reproduction, preparation of derivative works, and distribution. Courts routinely deny motions to dismiss where a plaintiff sufficiently alleges that defendant violated these rights in plaintiff's copyrighted software. And they go through some more citations. I don't know that they're necessarily citing to Judge Marshall anymore, but they wanted to make the impact that they know who the judge is, they've read his opinions. Nintendo has alleged sufficient facts to meet both elements. First, Nintendo alleged that it owns a valid registered US copyright, etc. Each work is sufficiently identified in Exhibit A. I'm not even going to look, I believe it. Second, Nintendo alleged that Storman violated Nintendo's rights. They alleged it. And that's really all they have to do. They allege that he made unauthorized copies of the video games listed in Exhibit A and displayed images of the box art and violated the rights by creating ROM copies, distributing them, and trademark too. Mr. Storman appears to have asserted 2 affirmative defenses to the copyright infringement claims, the first sale doctrine, and the DMCA safe harbor provisions. As a procedural matter, the motion to dismiss is an improper stage at which to resolve evidentiary-based affirmative defenses such as the first sale doctrine and DMCA safe harbor defenses. This alone is a reason to deny the motion to dismiss. But they continue. The first sale doctrine does not permit mass distribution of copyrighted works, copying of the copyrighted works, or distribution of those copies, or the creation and sale of derivative works based on Nintendo's copyrighted video games. And they cite 109A, we went over it before. Indeed, Mr. Storman's actions fall well outside the first sale doctrine. The first sale doctrine only allows an owner of a lawful copy of the copyrighted work to dispose of that individual copy. Mr. Storman is doing much, much more than simply distributing any copy of Nintendo's copyrighted video games he may have, if indeed he owns a lawful copy. Instead, he is reproducing the video games, creating derivative works, and distributing hundreds of thousands of those derivative works. The first sale doctrine does not permit such blatant infringement. So what would this look like? How could we modify the facts of this case to comply with the first sale doctrine? Think of GameStop. There is nothing wrong with GameStop buying your cartridges. I realize they buy them for $1 and nobody likes that they're real cheap. But GameStop is also a really, I'm going to be nice. I've had some really bad experiences with GameStop, not their employees. Their employees are fine. It's the managers and the game and the company's policies and things that just led me to stop doing any business with GameStop. And now I hear things like they're nearly bankrupt and are firing employees for violations of the social media policy that they just enacted. Maybe I'll link to, I forget which gentleman I've been watching on YouTube, but GameStop is having some trouble right now. But for our purposes, in this case, as a hypothetical alone, imagine GameStop. You bring your copy of Pokemon Shield and you say, I don't like this game anymore. I don't want this game anymore. I'm done with this game. Maybe you played it. Maybe you completed Pokemon. I don't even know how you do that. Maybe you completed Pokemon and you're done with it. So you go to sell your copy of Pokemon Shield. They buy your copy of Pokemon Shield. How do they buy it? You give them the physical copy. They're not buying your digital copy. They're buying your physical cartridge. If you don't have a physical cartridge, you can't sell them your digital copy because that's not covered by the first sale doctrine. So you bring them your physical copy. You give them your physical copy. You no longer have it. Now they have it. Somebody on the internet orders a used copy of Pokemon Shield and they go, great, we've made a little bit of money. They ship it to them. Nintendo can't come after them for that. That is protected by first sale and other laws, and there's nothing Nintendo can do about it. How can we now alter our hypothetical to come back? What is the thing that makes it illegal? Imagine you sell GameStop your physical copy. They take your physical copy. You no longer have your physical copy. They stick the cartridge into a machine that copies everything off the cartridge and then provides a digital file to be put on somebody else's machine. Even if they then destroy the original cartridge and sell that digital copy to somebody, that's not it. You are not allowed to transpose it like that, to transform it or transfer it into a different medium and then sell that new medium copy. You cannot buy a compact disc with music on it, transfer that to your computer, and then sell the digital files to somebody, even if you destroy the original disc. I realize that sounds like the spirit of copyright law, but that is not what copyright law actually says, and you cannot. Well, you can maybe get away with it at the small-time operation, but you're not going to get away with it at the big-time operation. The first sale doctrine does not permit such blatant infringement. And then, hey, look what they cite too. That was not why I was looking at it, but hey, we're thinking along the same lines. And then they go into the DMCA safe harbor provisions. Even if the heavily factual issue of DMCA safe harbor provisions were properly before the court, it's not. The complaint sufficiently alleges that Mr. Storman is ineligible for DMCA protection. Although Mr. Storman does not specify which of the 4 DMCA safe harbors he claims shelter under, he appears to be seeking protections under 512C. Mr. Storman fails to show that he meets any of the numerous requirements of 512C, including, without limitation, that 1. The infringing material must be stored by Mr. Storman at the direction of a user, 2. That Mr. Storman must not receive a financial benefit directly attributable to the infringing activity, 3. Mr. Storman must have designated a DMCA agent during the infringement, and 4. The required information for DMCA notices must have been included on the website. And on that note, those are all requirements, including that you have to designate a DMCA agent. If you do not, you are technically not in compliance with the DMCA either. So you must have a page that says, contact me here for DMCA claims. And of course, not receiving financial benefit directly. If he said stuff like, hey, pay me and you'll be able to download all these copyrighted works and I'm going to put Nintendo's works up, that's number 2. First, Mr. Storman controls and operates a website on which he uploads thousands of copies of infringing video game software, and then he organizes catalogs and offers those games for download to anyone who wants them. Remember the LiveJournal case where once they became aware of copyright infringement, by curating the content, by looking at the content and having employees select which content goes on the front page or something, that made LiveJournal liable for that copyright infringement. So if Mr. Storman has anything to do with that, then he is liable. He also reports the number of times each infringing video game is downloaded from his website. This is independently sufficient to remove him from any DMCA protections. Second, Mr. Storman receives a financial benefit directly attributable to the infringing material. He charges a premium membership fee that allows users unlimited and faster downloads of the pirated copies of Nintendo's video games. This, too, is an independently sufficient reason that Mr. Storman is not protected by the DMCA safe harbor. In lieu of demonstrating that he affirmatively qualifies for the DMCA safe harbor, an inappropriate effort at this stage of the litigation, Mr. Storman appears to assert that Nintendo has somehow granted statutory protection to Mr. Storman by sending a takedown notice. This is not the case. It is also improper to consider the email excerpt offered by Mr. Storman at the motion to dismiss stage. Okay. Whether Nintendo sent a DMCA notice is irrelevant to the question of whether Mr. Storman is eligible for statutory safe harbor protection. A service provider must itself comply with the various safe harbor requirements. And then they go on, although Mr. Storman's motion lists other various grounds for dismissal under Rule 12b, he does not provide material allegations or arguments to support. As to subject matter jurisdiction, he does not deny that Nintendo has alleged claims under the Lanham Act for Trademark and Copyright Act, and that the subject matter jurisdiction is therefore proper as federal question jurisdiction under 28 U.S.C. 1331. This court's original jurisdiction over trademark and copyright claims is under 28 U.S.C. 1338, and supplemental jurisdiction over the state law claim is proper under 28 U.S.C. 1367. As to personal jurisdiction and venue, he does not deny that he resides in this district, nor that a substantial part of the activities giving rise to Nintendo's claims occurred here. To the contrary, on his motion, he claims an address in Covina, California, which is in this district. Moreover, Mr. Storman does not suggest that some other jurisdiction or venue is appropriate or more convenient. On this record, the court need not entertain Mr. Storman's jurisdictional musings. For the foregoing reasons, Nintendo respectfully requests the court deny Mr. Storman's motion to dismiss. And then they have a footnote. Nintendo has attempted to generously construe Mr. Storman's arguments and respond to those it understands to the extent the court determines that Mr. Storman has raised other cognizable arguments that Nintendo has not addressed. Nintendo respectfully requests it be given the opportunity to provide supplemental briefing to respond to those additional arguments. Because his arguments were so unclear, if they missed one, Judge, please let us have a second chance. I agree. His arguments were incredibly unclear, so incredibly unclear that it discredits him. So,
are you using a pro se standard there, though? Because in terms of pro se, it wasn't horrible. It was just incorrect. And I consider clarity and incorrectness to be two separate things.
Well, it also smacks of someone who doesn't want to hire an attorney, trying to do it themselves. This is the kind of thing you need an attorney for, and that attorney needs to be fairly compensated for the quality of the work that they're doing. And I don't know, it's sometimes a little bit off-putting that that people disregard the need for some level of counsel. If his website is this popular and people are paying for it, he's probably got the money to hire an attorney. So doesn't this seem a little bit underdone, a little bit undercooked for the level of liability this person's facing? We're talking about 400,000 downloads at least. I don't even know, it might be more than that alleged. It might be more than that at the end after discovery too. And we know that $750 per title is the minimum statutory damages, and willful copyright infringement can go up to $150,000 per infringement. So let's not get into the absurd. Let's use a smaller number. We've seen judges do $2,250 for BitTorrent-based copyright infringement. So, and I think that's a minimum number because this is beyond that. This is for the redistribution of the files and not just, him copying them to his home computer so he can play the games. So you're talking about 2,000 times 400,000. You're talking about $1 billion in liability here. Let me get out my calculator. Let's see, 2,250. No, how did you get square root out of that? Oh, is $900 million in liability. And that's a very conservative estimate of what this could be. So if you had $1 billion lawsuit against you, don't you think you'd go and hire an attorney to defend you? Just saying. He might be disregarding the level of lawsuit and exposure and liability that he's got here. The $1 billion ROMUniverse lawsuit. And here's the other part, Tech. As far as if they are a pro se litigant, if they say the wrong thing in one of these pleadings, they might admit to allegations or they might waive a right. Or, for example, I said if they answer a complaint, they lose some 12B motions to dismiss. I believe even 12B6 is one of them. I don't think you ever lose the jurisdiction argument. I'll rephrase that. I don't think you ever lose the right to bring the jurisdiction argument under 12B1, but I think you lose most of the other 12B arguments if you answer the complaint before filing a motion to dismiss. So, for example, a pro se could mess that up by filing an answer not realizing that they eliminated their rights to certain motions to dismiss. That's just an example. That's not what's been done here. This is an example. But so he might have said something in there that Nintendo can then turn around and use. For example, he said that they didn't have proper jurisdiction and venue in the Central District of California, and then he listed a Covina, California address. So that undoes his own argument. Do that too many times, and they just file for summary judgment and win $1 billion. Now, is ROMUniverse's owner going to be able to pay $1 billion? I don't know. We'll see how many of these $30 fees they collected. I don't think it's $1 billion worth. Most people don't keep the $1 billion laying around. They spend it. So all of that will come into it, and Nintendo will then start looking for the money. They'll get an injunction. They'll get the court case to a judgment, and then they will have every right to go looking for the money. So I'm very concerned about whoever would make these defenses in such an important court case, because it's $1 billion on the table, man. It's more than that.
And a misunderstanding of the safe harbor for DMCA, that safe harbor was supposed to be for websites that are not aware of all of the user content, that if a user posts something inappropriate, that as soon as the website becomes aware of the inappropriate content, it removes it. But if he's advertising that new content is coming, if he is making any of the ROMs himself, anything like that where he's hands-on with content or content curation, then he's no longer ignorant of what's on there, and he can't sort of claim that he has nothing to do with it. So they should go after the original uploader.
All right, so what do you think of ROMUniverse and the $1 billion lawsuit over Nintendo ROMs? Geez, I think that I think this guy should take this seriously. This is a serious case. Nintendo has prosecuted these kinds of things before. Let's see what they are looking for. Nintendo is looking for statutory damages of $150,000 each and $2 million for each trademark. Oh yeah, I forgot about the trademarks, so we get to add trademark damages in there too. An accounting of all profits and an award of punitive damages. I love Adobe. Come on, Adobe, you can do it. An accounting of the profits, a permanent injunction, permanently cease and desist from copying, distributing, selling, performing, etc. Destroy all the unauthorized games and copies. Transfer all domains to Nintendo. Yeah, I have a feeling by the end of this, Nintendo is going to own NDS Universe and ROMUniverse.com. We will see.
Starting to sound like change your name and flee the country bad.
Or get a good attorney, not me. We're involved with too many other things right now, and start talking to Nintendo. But that's the appropriate level of legal advice, is go get an attorney. Go get a good one, a good attorney, and pay them up front. That is our show, everyone. Thank you for joining me. I am Leonard French, your favorite copyright attorney. I am looking forward to the new year, and we'll probably do something like a year in review live stream on the 31st, where we will try to look at some comments and stories and things and go over it all for maybe another 2-3 hours and hang out. I think that sounds like fun. Do you think that sounds like fun? Oh, well, she's gone. So thank you to our supporters on patreon.com/ljfrench and sponsus.com/law. At the $50 level for the month of December, thank you to Aspernari, John Steele, Gavin Barnard, Eevi, Kyle Mudrak, Michael Pearce, Spirit Bear, Jan Negrey, Daniel Perez, Snorre Wisotzky, Blackleaf, Joe Tyson, Benjamin Hitov, Stephen, Rumble in the Bunghole, and Cute Grills in your area. And thank you to the $5 plus supporters who will be in the description below and crawling on the screen in front of me. I wish everyone a very happy New Year's celebration. We're going to the Efteling, which is a amusement park in the Netherlands, and I'm very grateful to Kaylee's family who bought us tickets. We're going to drive there tomorrow and spend the day there, so maybe we'll have some good pictures and video for you from the Efteling. Thank you very much for joining me. I'm Leonard French, your favorite copyright attorney. Love you all. Bye.